depending on, Texas is easy with respect to probate law. But if you've got a state like Florida or California, where you've got dependent administration, which means you can't so much as sell that house without approval from the court, it's an expensive endeavor to have to do a probate outside of the state of Texas. So
what was the clause that you said that's called a transfer on death?
Transfer on death deed. What that says is, and not all states have got transfer on death deeds. Texas does. I know that Colorado does, because I just did one in Colorado. But the list of states that have transfer on death deeds is growing.
Okay.
I mean, it's a cheap way to make sure that your real estate passes to whom you want to get it at your death. So it's kind of a cheap will, but it's a great way for assets to pass. Which sort of brings me to one other thing. Dying without a will or a living trust or a transfer on death deed, when the only asset you own, or the only asset that doesn't pass outside of probate, if you've got a bank account that passes to someone as pay on death, so say your brother died and named you as the pay on death beneficiary, all you have to do is go to the bank, hand them a death certificate, and they will turn the account over to you. If you don't have something like that for real estate, we generally, in most states, but not all, have something called an affidavit of heirship. And what it does is it allows the transfer of real estate without getting a court involved. And what it consists of, and usually this works well for a surviving spouse where all of the children come from one marriage.
Right.
So if you've got a surviving spouse, or the surviving spouse dies and you have no will, and all the children are from the same marriage. It's something where you literally find out the family history. This person was born on this date. They were married to Jane Doe was married to Joe Foe, and they had 5 children. They married on this date. They were married at the time of death, and this is the real estate they own. You get 2 disinterested witnesses, friends who know your family history. You have them sign the affidavit. You record it in the county and state where the property resides. And generally, title companies will allow people to sell property on those affidavits. In other words, those affidavits of heirship will be used to vest title in the appropriate family members without the necessity of a will or a probate.
Wow, I never knew that.
And it doesn't always work, but it works more often. I am in no way proposing that people not have a will or a living trust or something that disposes of their property at death. But as a fail-safe, this works in a great deal of the places, and there are more and more states that are accepting these as well.
And not that this has a lot to do with real estate, but you also do pretty much all of it, which would include medical provisions as well, right?
That is correct. We do. The basic, when you hear people talking about an estate plan, when you talk about middle income, just an average individual talks about an estate plan, and someone thinks, well, I didn't know you were rich. Why do you have an estate plan? What they're really talking about is having documents in place to deal with death or disability. So they're talking about having a will, which can be a will doesn't have to be anything other than you name your spouse as the beneficiary. If your spouse predeceases, then you name your children. You name an executor who's going to have the will admitted to probate. They're going to reach out and grab the assets of the deceased. They're going to pay the bills, and they're going to transfer the assets to the individuals named in the will. If you've got kids under the age of whatever age you want your children to get assets, you can have what we call a testamentary trust, so that you name a trustee to manage assets for children until they reach a certain age. So
would a trustee usually be like a business entity type trustee, or a family friend?
That's a very interesting thing. If you've got a family member or a trusted friend That's going to, for most people, that's going to be who you're going to want to go to. We have had banks for years that we've used as backup for to serve as trustees. But of course, they have professional money managers there. They have people who are professional trustees who know what the rules are. But most of the big and medium-sized banks and trust companies are no longer accepting trusts of less than $1 million to $1.5 million, which leaves well over 50% of people out there with not good alternatives if you don't have a friend or family member to be trustee for you. So I have this situation now with a deceased client of mine who died fairly young of cancer and trying to take care of her children. Well, I have luckily found several different places who take either a private fiduciary, which would be an individual who serves as a fiduciary, or a very small bank, or mostly a credit union or something, who will serve as trustee, but they're very difficult to find. This is a fairly new thing, and it's a very scary thing for moderate families with a very moderate or modest size estate.
Right.
But it is, and I think attorneys are getting better at finding the people out there who can serve as a private fiduciary, because we have all been scrambling for about the past year trying to find people who can take care of our clients' kids if something happens at an early age. But so besides having some instrument that disposes of your assets at death, usually we're talking about a will or a revocable living trust, we also do powers of attorney. In Texas, we have what we call a statutory durable power of attorney, which usually deals with financial assets. We generally have you set that up during lifetime, and it's called durable because we put it into effect before you're disabled, and it remains in effect in the event you become disabled. The agent can still step in and can still manage assets for you.
Right.
So that's a financial power of attorney. Let me say something about it, and if I'm talking too long, let me know. Let me say a little bit about title. If you are trying to sell the assets of an incapacitated person, whether it is your spouse and you're only talking about their 1/2 community property interest in real estate, and that spouse is incapacitated, the problem with the title companies accepting this power of attorney is the day of closing, whether it's closing on the sale, the purchase, or refinance. The title company wants to speak to the principal to make sure they're still living, and they still want the person who's named as agent to be their agent. Well, if you've got someone who's got dementia, that's not going to be a possibility. So the statutory durable power of attorney I use, I have added language beyond just what the state legislature has made a promulgated form that says it gives the agent the ability to transfer assets into a living trust, into a revocable living trust that has certain provisions in it. The trustee can then transfer the agent can transfer the real estate into the living trust, and then the title company will let the trustee of the living trust sell the asset.
Right. Smart.
So we have to be very careful about what provisions are actually in our powers of attorney to make sure they're going to take care of contingencies if there's a problem with the client. So beyond the financial powers, we have medical care documents. A medical power of attorney. You will always make your own medical decisions as long as you have capacity. The doctors and medical places will always look to you to make your own decisions if you can. So we've got a medical power of attorney. We have a directive to physicians, which is the document that says, I do or do not wish to be kept alive on life support. And then we've got a HIPAA authorization. HIPAA is the federal privacy law. Many doctors' offices and hospitals have their own form for you to file. We have one that's sort of a multi-purpose that you can sign it. We can make copies. We can email them to have them at your doctor's office or a hospital if you're going to have a medical procedure or something like that. So all of those things are important, but that's what a basic estate plan is for a moderately, a family of moderate wealth. It's still a necessary thing for you to have to make sure your bases are covered.
What do you think about this same sort of scenario as far as the demographic of an individual? And I run into this a lot with investors where they usually own their own home.
Mm-hmm.
Sometimes when I meet an investor, they already have maybe one investment. Typically, my investors set goals for purchase cadence, right? So some investors purchase every quarter. Some purchase once a year. It just depends on their goals and abilities, of course. At what point, and I'll kind of tell you what I think, and then you can tell me, punch bullet holes in my ideas. But a lot of times people will ask me, should I get an LLC and purchase my investment in the LLC, or should I buy the investment and then put it in an LLC? And should I have a different LLC for every investment? And this is sort of my thought philosophy, right or wrong. It is kind of going back to what you said earlier, is that the design in cocooning these investments, in wrapping them, like you said, in an LLC, is to protect yourself from liability. And if you do purchase this investment, we'll just say it's a $1 million property, you put 20% down. Your ownership in this property is minuscule. And the mortgage will always have first position. And so I'm always thinking, maybe buy the house first, maybe even buy another house, so long as you're falling into those kind of 20% down rhythms. Totally different scenario if you're paying cash, or maybe rolling large sums of 1031 money where your ownership position is much greater, which means your liability can be a lot bigger. So I would say this is almost like on a case-by-case basis, but let's just assume 20% down, you buy a house. Next year, maybe you buy another house. Third year, you buy another house. Maybe at that point, depending on market conditions, we should go back and look at that first asset. How much has it appreciated? Where's your ownership percentage really gotten to? And is it at a point, and to your point as well, like who's your occupant, that we should start thinking about protecting the asset?
Well, you hit the nail on the head. I believe your analysis is a very good one and a very valid one. Here's the rub over which we have no control. And I do not understand this, but this is the way life is. Lenders in Texas will not lend to an LLC.
Yes,
they just won't. I have no idea where that came. It doesn't matter if it's a sole member LLC. So you've got an LLC that is 100% owned by the person who owns 100% of the home outright.
Right.
So they're not going. So if someone has an LLC and says, my LLC is going to buy this property, no lender's going to lend to them.
Right.
So they're going to have to buy it outright. Yeah. And so continuing on, you go back and you look.